it doesn't mean I'm entitled to speak without being fired for it by my private employer, or without being ejected by a private property owner, or being expelled by a private university. It's only a right as against the government. I can't be thrown in jail for it by the government. Maybe I can't be fired for my speech by a government employer, but it just doesn't apply to private action. And so at the time, there was something that was labeled the bad tendency test.
Bad tendency test?
Bad tendency test. That speech could be restricted if it has the tendency to promote crime, including revolution, including draft resistance, including all sorts of criminal conduct.
So based on what you were saying, Professor Volek, the burning of the flag, the U.S. flag, even though many may see it as an abhorrent act, is protected by the First Amendment?
Well, the Supreme Court has said that it's protected in two cases, Texas v. Johnson, 1989, and U.S. v. Eichmann in 1990. The Constitution protects all sorts of things, including free speech, but also the democratic process and the war power. And if what you're saying interferes with the government's ability to exercise its war powers, then that speech is itself kind of counter-constitutional.
Professor Volek, it's a pleasure to have you on our program. Thank you for taking the time for this conversation with me. As I was preparing for this interview, I decided that it behooves me to actually read the text of the First Amendment, since we're going to talk about it. And I must confess, I had not read it since my law school days. And when I read it again this week, I was surprised by how many questions I actually had about the text itself. So let me stop here and ask you to please tell us, what does the text of the First Amendment tell us about freedom of speech and press?
Well, so the text is obviously important. It has particular features in it, some of which have ended up being important elements of the case law, some of which, perhaps surprisingly, have been more or less ignored.
Ignored. Huh.
The most obvious example is the first word, which is Congress. Congress shall make no law, and then I omit the religion clauses, abridging the freedom of speech or of the press. Well, you might think that means only Congress. And indeed, it only meant the federal government at first. Up until after the Civil War, the First Amendment was broadly understood, and I think correctly understood, as only applying to the federal government. But it doesn't mention the president. It doesn't mention the federal courts.
Yeah.
Quite early on, I mean, several decades into the Republic, courts began to just sort of assume that it applies to the federal courts. And since then, it's been clear that it's also been applied, that it should also be applied to the president. But that's not quite how it's written. And this is just a reflection of the fact that American courts, and I'd say Anglo-American courts more broadly, but let me speak specifically about American courts, they take seriously constitutional text, but in part because constitutional provisions are often very brief and don't capture a lot of detail, they have been quite willing to go beyond the text in certain respects.
I see.
Some of that, I think, has drawn a lot of criticism. Some of it people have just generally accepted because, yeah, it does make sense that if Congress can't abridge freedom of speech or of the press, why should the president, who is usually acting pursuant to congressional act, and even if he's not, is still a government official, why shouldn't he be bound by it?
Exactly. Two follow-up questions, Professor Volek, on that sort of initial point. One is that have there ever been case laws that have pushed back on this, saying that, no, this only applies to Congress? That has never happened, right?
No, Congress as opposed to the president or the federal courts, no. The Supreme Court has generally just accepted
I see.
That it ought to apply more broadly.
And the second question, if I may, please, the reason that the First Amendment starts with Congress shall make no law, is it because during constitutional debates in 1787, did they think that Congress is more powerful, hence they just thought of Congress? Or is this a non-starter, this question that I'm asking?
So it's an interesting question. We don't have a lot of detail on
Hmm.
that particular issue,
Hmm.
but I think it was generally understood that, first of all, Congress probably would be, in most respects, at least as to domestic matters,
Hmm.
the most powerful. As to foreign policy matters, the president has much more authority. But also, relatedly, the things that probably came to their mind um, that would restrict speech or press needed congressional authorization. I think it was, for example, the classic example of what would be forbidden under the Free Press Clause was a licensing scheme where, in order to be a printer, you had to get a government license
Oh,
that the government
wow.
could deny to people um, who whose views it didn't like. That was a classic example of what would be forbidden, and Congress clearly had no power to create such a licensing scheme. But I think it was just so clear in light of the structure of the Constitution that the president had no power to do that. I don't
Yeah.
think anybody was thinking, well, what if the president tries to do it?
Yeah.
Because the
Yeah.
president has very limited authority to enact new rules that govern you and me
Hmm.
just by executive fiat. On the other hand, of course, the president today does have power, or excuse me, of course, today we see examples of where the executive branch would have considerable power over speech, in part because it's gotten so large, has so many
Yeah.
employees. The president's power to hire and fire people or authorize his subordinates to hire and fire people could potentially seriously implicate the First Amendment if, for example, he says, I will only hire people of one party. Or I will fire anybody who has expressed any views that are critical of some policy that I disagree with. But at the time, I think the First Amendment wasn't seen as particularly focused on those kinds of administrative actions.
Hmm. Hmm.
So a lot has changed since the framing era, and certainly the court's understanding of the breadth of the First Amendment, I shouldn't say necessarily has changed, but it certainly has become much more detailed. A lot of questions, I think, back then were not much resolved and not even much talked about.
Yeah.
Since then, of course, we've had to resolve them.
What else is there in the text of the First Amendment that you share to highlight here?
Well, so some people point to the word the, make no law abridging the freedom of speech.
Huh. Huh. Okay.
Or of the press. And the argument is this, and I think there's something to it, although it's a little bit of a joke to say it's all about the word the. It's maybe about the word the, but also about broader ways
Yeah.
that courts use to understand law and especially constitutions. So the theory is that it's not every instance of speech or every use of presses that is protected. Rather, there is a concept, the freedom of speech and the freedom of the press, that was at least in some measure understood, even if by no means fully worked out, by the framing generation. And that is what they were seeking to protect. So
Does the word the mean that it's definable?
That is not just definable, but that it's something that was at least in some measure defined. So just to give an example, throughout American history, it has been understood that libel, which is to say, let's just focus on the modern definition, which is false statements about particular people or businesses that damage their reputations. That libel was not protected by the First Amendment. The First Amendment and its state constitutional law analogs have always coexisted with the body of law, including, by the way, criminal liability law, but also these days in predominantly civil liability, that has allowed punishment for and compensation based on false statements that damage people's reputation. Now, nothing in the First Amendment says except for libel. Now, some state constitutions do either mention libel as punishable or have other language that would allow it as a matter of text to be punished. But the federal constitution and some other state constitutions just say the freedom of speech or of the press. Well, the theory goes, the freedom of the press was always understood as limited by traditional recognition of people's rights not to be libeled. So the freedom of speech or of the press is freedom of that was understood at the time, which excluded libel. Now, perhaps even setting aside the point, you might say when a constitution uses particular language, it borrows whatever legal understandings may have been present of that language at the time, even in the absence of the. But the is just what some people point to as a reminder that there's a pre-existing concept that the Constitution was understood as embodied.
That freedom of speech and freedom of press are not absolute. There are some sort of it is prescribed to some limits.
Right, but it's not just that it's not absolute; it's that it has historically recognized exceptions.
Interesting.
So this is an argument often people make when they say, we don't think the Supreme Court should just come up with new exceptions or new doctrines just because it thinks they're a good idea. But it should recognize that there were some historically recognized exceptions that need to continue to be recognized. By the way, of course, Supreme Court has changed libel law in light of free speech and free press principles quite a bit. There's some pushback against this now from some justices, but throughout American history, it's recognized there's at least some room for libel law. Let me give you one other example of constitutional text that the court may have departed from, but I think for historically sound reasons. So the freedom of speech or of the press, read literally, suggests that it covers my speaking and the press, the use of the printing press. Perhaps changes in technology, maybe the use of any mass communication technology. But you might say it doesn't cover symbolic expression, like burning a flag or waving a flag, for example. But in fact, if you really want to be literal about it, you might say it doesn't cover handwriting, because handwriting is not speech in at least the oral sense of speech. It's not press. What about pictures? What about like cartoons that do not have words? Are those covered? It turns out that the Supreme Court has long recognized that it protects, at least in some measure, symbolic expression. In fact, basically, in 1931, that was the first time that the Supreme Court actually set aside government action on First Amendment, or for that case, First Amendment is applied to the states grounds. And the very first such case, Stromberg v. California, involved symbolic expression. It involved the right to wave, in that case, a red flag as a symbol of revolution. And I wrote an article some years ago on symbolic expression and the original meaning of the First Amendment. And I looked at some historical evidence. And it was pretty clear that in Anglo-American law at the time, verbal expression with words, whether printed or written or handwritten or spoken, pictorial expression and symbolic expression were basically treated the same way. They were treated the same way for purposes of speech restriction. You could be sued or prosecuted for libel if you use certain conventional symbols in order to damage someone's reputation. And to the extent people were talking about protecting speech and press, it was again understood that symbolic expression, pictorial expression, and verbal expression were on the same footing.
So based on what you were saying, Professor Volek, the burning of the flag, the U.S. flag, even though many may see it as an abhorrent act, is protected by the First Amendment? Well,
the Supreme Court has said it's protected in two cases, Texas v. Johnson in 1989 and U.S. v. Eichmann in 1990. Again, waving the flag is just as much symbolic expression as burning a flag. Yeah. And waving a flag has long been understood as protected.
So if that's the case, Professor Volek, President Trump issued an executive order in which, I don't remember the exact text, I reviewed it, I think he outlawed it. If
you're talking about this year's executive order, the executive order was deliberately narrower than just trying to outlaw flag burning, in part because it grudgingly recognized, but recognized those precedents. So if you look at the relevant part of the order, it says the Attorney General shall prioritize the enforcement of criminal and civil laws against acts of American flag desecration that violate applicable content-neutral laws while causing harm unrelated to expression consistent with the First Amendment. So what does that mean?
Yeah, translate that for us, please.
Right. So he's saying that when a flag burning violates a content-neutral law, so not a law that targets flag burning, but maybe a law that targets theft and destruction of property when someone steals an American flag and then burns it. Or there are sometimes content-neutral laws that bar the burning of certain things in certain places. I'm in California now, and we know the danger of fire. And in fact, the order gives as example violent crimes, hate crimes, although in exactly the context would be hard to see, and crimes against property and the peace. So one classic example would be crime against property, would be burning against someone else's flag.
So I come, if I may just share two analogies, and you tell me if I got this right or not. So if I have a U.S. flag, and I'm not saying I'm going to do this, I go to my backyard, there's no fire hazard conditions, and I burn it. That's my thing, or even my front yard, as long as it doesn't violate association rules. That's fine. But if I come in and steal your flag, or if I go get a flag and burn it in fire hazard conditions, let's say in an Arizona or California national park or state park, I'm violating actually other laws by burning that flag. I could be burning a piece of cloth at that point, but because that cloth belonged to you and I stole it, or that I burned that cloth in a fire hazard condition, that's really the issue that's being addressed by President Trump's executive.
Now, this having been said, I still think that the prosecutions pursuant to that order would still be unconstitutional. Because even when you're enforcing a content-neutral law, if the reason that you're enforcing it is that you disapprove of the viewpoint being expressed, like hostility to America being expressed through burning the American flag, that kind of viewpoint-based targeting, even under a facially content-neutral law, viewpoint-based application of a facially content-neutral law, is unconstitutional. There are cases on that. RAVV City of St. Paul is one. There are others. So I actually think this executive order is somewhat counterproductive, because anytime somebody is prosecuted for burning an American flag that he stole under some destruction of property rule or theft law, he can say, oh, but the real reason you're going after me, see this executive order, is you don't like the fact that I'm burning the American flag, as opposed to just random.
Oh, I see. So the better path is to prosecute him for theft.
Yeah, just prosecute him for theft and not have some special rule, which would be an unconstitutional rule targeting theft of.
I see. That's really interesting.
Right, but this having been said, much as I disapprove of the order, I want to make clear that the order does not purport to ban all flag burning, because it recognizes, again, grudgingly, disapprovingly, but recognizes that Supreme Court has said that laws that target flag burning are impermissible restrictions.
I see. Let's go back to the text of the First Amendment. We talked about freedom of speech and press in the context of the text. I'm sure there's much more to talk about. I want to talk about the last two sections or clauses of the First Amendment. Congress shall make no law, blah, 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 or the right of the people peacefully to assemble and to petition the government for a redress of grievances. Are these two last clauses, Professor Volek, also under the rubric of free speech and free press?
Well, they are separate clauses, but they have been treated as basically applying free speech and free press principles to.
To go to protest.
Right. and to petitions, including, by the way, lawsuits, which are treated as a form of petition of the government, albeit of courts. So here's one way of thinking about it. The court these days talks about freedom of speech usually as a shorthand for speech, press, petition, assembly. You could see cases which involve the printing press or the internet, which is the modern analog of the printing press, where it's talked about as a free speech issue. Likewise, you could have a situation where there's a restriction on in-person assembly. It's a free speech issue. But
it's a shorthand
because it's nice shorthand.
Yeah.
But let's say the Constitution had just said the freedom of speech. I think a government official could say, wait a minute, freedom of speech, if you're just talking to some people, of course we shouldn't restrict it, but the press is much more dangerous than ordinary speech. The press could have these views, could allow your views to be sent out to thousands, hundreds of thousands of people.
That's interesting.
That makes them more dangerous. It doesn't have the in-person conversations. So it's more likely to be misunderstood. There's less opportunity to kind of clarify or correct. So in fact, English law had long viewed the printing press as with more suspicion than ordinary speech. Likewise, you could say, well, freedom of speech, yes, speech is all good, but when you've got a whole bunch of people gathering together, that's not just speech, could be intimidating, could block traffic, could do all sorts of things. So you could speak all you want, but if you gather in groups of 3 or more people, that's not allowed. Or petition. If you go to court, well, that has legal effects. It's not just speech. Even if you send a petition to the government, you're formally asking for a certain government action, and maybe that should be viewed differently. So this is a way of making clear that all of these forms of expression, all of these forms of communicating one's views are generally protected, but subject to some exceptions. And it turns out that the exceptions, like for libel and such that the court has applied, it's applied pretty evenly under these clauses.
One last question on the text, please, Professor Volek. You know how I read you the penultimate clause? I'll read it again. Or the right of the people peacefully to assemble. When we talk about freedom of press and speech, it doesn't say the right. In fact, there's nothing that says it's a guarantee. We're rather prohibiting Congress from doing this. Is this like a distinction without a difference?
Generally speaking, the court has not drawn much of a distinction here. After all, this all appears in the Bill of Rights and was pretty early recognized as the Bill of Rights. And that's in part because it was modeled on the English Bill of Rights, which was at the time 100 years old and very familiar to Americans who had until recently just been Englishmen, right? So you look at the First Amendment, the petition clause talks about a right. The Second Amendment, the right of the people to keep and bear arms, is a right. Fourth Amendment, right of the people to be secure in their persons, houses, papers, and effects against unreasonable searches and seizures, is a right. But then you have the Fifth, Sixth Amendments, which provide very important protections both in the criminal justice process and against being deprived of liberty or property without due process and against taking of private property. All of those are properly understood as rights. I think people in the framing era saw them as rights. The fact that the word right wasn't used is not tremendously significant there. In some other situations where there's a question of whether it's an individual right or not, and then it might be the presence or absence of the word right might be significant. But I just don't think this was something that the framers viewed as particularly important.
I see.
And then let's say the presence or absence of the word right in the First Amendment.
Or the fact that it's not written as a guarantee, rather as a prohibition on Congress. That also doesn't make that much of a difference.
Well, yes, it hasn't made much of a difference. Again, the Fourth Amendment has this right of the people, and the the Assembly and Petition Clause has the right of the people. Free speech and press they've been treated the same way. It is important to realize that that whether it's labeled a right or not, it is only a right against the government. And that's partly because the first word is Congress shall. At least that's a clearly governmental entity, but partly just because of the way these kinds of constitutional rights have generally been understood in American law. which is that it doesn't mean I'm entitled to speak without being fired for it by my private employer, or without being ejected by a private property owner, or being expelled by a private university. It's only a right as against the government. I can't be thrown in jail for it by the government. Maybe I can't be fired for my speech by a government employer, but it just doesn't apply to private action. A few constitutional rights in federal constitutions, some state constitutions do apply to private action, but the Bill of Rights does not apply to private action. And
so that's why Disney can tell Jimmy Kimmel you're suspended at least for a few days and then decide whether or not wants to fire him.
Exactly. That wouldn't be a First Amendment violation. Now, the government pressuring Disney, at least trying to pressure Disney into suspending Jimmy Kimmel, that may very well be a First Amendment violation. But Disney's actions by themselves are not. Now, there are statutes in many states, not all or even most, but a considerable number of states that do limit private employers from firing their employees based on their speech. But that is not the First Amendment that does it, it's state statutes. If you want to look at an analogy, the Equal Protection Clause of the 14th Amendment bans discrimination based on certain attributes, especially race discrimination by the government. But a private employer, if a private employer decides not to hire me because I'm white, or not to hire someone because he's black, that doesn't violate the Equal Protection Clause. It's still illegal, but it's illegal because there's a federal statute, Title VII of the Civil Rights Act, which generally prohibits race discrimination in employment. There are state statutes that prohibit race discrimination in employment, but it's those statutes, not the Equal Protection Clause, that do that. Likewise, with regard to protection of speech against private employers and some other private entities, there are statutes and other state law rules that may prohibit that, but as to private entities, but it's not the First Amendment.
It's not the First Amendment. Two follow-up questions, Professor Wallach. One is just for my own edification and clarification, I guess, for our audience as well. How did the First Amendment's application to the federal government go down to the state, city, municipal, county levels?
Yes. So the answer is that it took the 14th Amendment after the Civil War.
I see. And so up to after Civil War, the First Amendment didn't really apply.
Right. There were state constitutions had their own free speech and especially free press provisions. And state governments were bound by those constitutions, but those are a matter for state courts to determine, generally speaking. Mm-hmm. It wasn't a matter for the U.S. Supreme Court to consider, which is one reason why there are very few U.S. Supreme Court cases dealing with the First Amendment during the 1800s. So one way of thinking about it is the Bill of Rights was enacted at a time when the federal government was just created. States, people kind of felt connection to their states, and in some measure trusted their state governments. At least the state governments were nearby, and they were worried about the new federal government. So the Bill of Rights was a means of restraining the federal government. Mm-hmm. Then the experience with slavery and experience with restrictions on, among other things, speech and press and keeping and bearing arms by states that were seen as, among other things, means of trying to protect slavery. Those restrictions were seen as means to try to protect slavery, made Congress and many states suspicious of state power and state abuses, or I shouldn't say suspicious of state power, but concerned about abuses of state power after the Civil War. So the amendments that followed the Civil War, the 13th, 14th, and 15th Amendment, which dealt with slavery, and then among other things, equal protection, and guaranteeing right to vote without regard, or at least aiming to guarantee for a long time unsuccessfully, but still aiming to guarantee the right to vote without regard to race. All those were primarily constraints on state power. Mm-hmm. Now, for complicated historical reasons, they weren't fully recognized as such constraints on state power until the 1900s. It wasn't until the 1920s that the
Wow.
Supreme Court made clear that, for example, the free speech clause applied to the states through the 14th Amendment. It wasn't until the 1960s that it was clear with regard to many um, of the criminal procedure amendments. Indeed, it wasn't until 15 years ago that it was clear that the Second Amendment, the right to keep and bear arms, applied to the states of the 14th Amendment. Then since then, the court applied the excessive fines clause. There are a couple of provisions of the Bill of Rights. The Seventh Amendment, which secures a right to civil jury trial, and the grand jury presentment requirement for indictments in certain criminal cases that has not been applied to the states. And in fact, there's precedent that says it doesn't apply to the states. This is a process called selective incorporation of the Bill of Rights. So that is itself an interesting and complicated historical process.
Wow, this is fascinating. We're constantly revisiting the scope of the Bill of Rights, even to this day. So let's go back to Jimmy Kimmel for a second. Has any such an issue ever been litigated? Has in our history anyone ever come and said, look, I work for a private entity, they fired me, or they did this to me, they limited my free speech, and this is because government was pressuring this private entity to do that?
Yes. Well, not just in our history. It happened last year.
Last year.
And actually, I was involved in that case. I represented I was one of the many lawyers representing the National Rifle Association in a challenge to New York state officials' actions. And here's what the NRA alleged, and these were just allegations. There hasn't been a trial on that. The question is whether, if the allegations were true, would it be a constitutional violation? The NRA alleged that the quite liberal left, let's say, New York government, it was Governor Andrew Cuomo and Maria Vullo, who was his head of financial services regulation, that they pressured private entities, financial intermediaries, including insurance companies, to cut off or to reduce ties with the National Rifle Association because they disapproved of the NRA's arguments in support of gun rights. Now, of course, an insurance company isn't itself bound by the First Amendment. Again, it's a private entity. If an insurance company says we just don't want to do business with you, generally that's perfectly legal, unless there's some specific law that prohibits them from discriminating on certain bases. But the NRA said they didn't do it just on their own, the insurance companies. They did it, the claim went, because the state authorities were pressuring them, using the threat of the state's regulatory power.
Wow, the Cuomo administration.
Exactly. And the Supreme Court unanimously said, yes, if that's proved, that would be a First Amendment violation. Precisely because it's the government using the threat of coercive power or coercing people through the threat of various investigations, sort of civil prosecution, those kinds of things, coercing people into restricting someone's speech. So again, it didn't involve employment, but it was structurally very similar. There was a case some 60 years before, Bantam Books v. Sullivan, where in the state of Rhode Island, there was a commission that was trying to restrict the sale of what it saw as obscene material. And there is an obscenity exception. At the time, it was probably seen as even rather broader than it is now. It basically refers these days to really hardcore porn. At the time, I think many people viewed things that today would be seen as pretty normal as obscene. But in any event, the commission basically threatened bookstores with prosecution. It had no prosecutorial authority, but it had the ear of prosecutors. Threatened bookstores with prosecution if they didn't take certain books off their shelves. And many of the bookstores said, okay, fine, because these were not themselves porn bookstores. Again, many of them today would be seen as mainstream books. The bookstore figured, okay, look, if we take this one book off the shelf, we're going to lose a few sales. but we're going to save ourselves the risk and the expense of being prosecuted.
Yeah.
So this pressure was potentially quite effective. The book distributors, the publishers, then sued, and the Supreme Court said, yes, the commission is again trying to coerce.
Did they sue the commission or the bookstore chain?
They sued the commission because again, the bookstores, they didn't violate the First Amendment. The bookstores weren't bound by the First Amendment. Yeah. In fact, a bookstore would probably have its own First Amendment right to choose which books to cover. Of course, it's just that the government is not allowed to try to pressure the bookstore into doing that.
Have any such, wow, that is fascinating. Have any such cases ever been brought against a U.S. president?
Well, no, but this wouldn't be brought against a U.S. president either, right? I mean, the primary threat was, well, Trump did talk about these things. The clearest threat was from Brendan Carr, who is the head of the Federal Communications Commission. And the likeliest source of enforcement would be Carr.
Yeah.
Trump would not have direct enforcement authority, even though, of course, he could pull the strings behind it.
Yeah. And I wasn't so much talking about our current president, Mr. Trump. I was just generally, like, for example, any of the prior presidents.
Well,
especially in the 1920s when we had the Red Scare or anything like that. I was wondering.
I mean, if you're talking about these kinds of cases involving like Bantam Books v. Sullivan, as I mentioned, NRA v. Vula, there are such cases. It's just that they don't happen all the time. Yeah. By and large, so both of those cases involved state government action, just because state governments tend to do a lot more.
Yeah,
certainly historically have done a lot more along these lines than the federal government. So in fact, actually, the great bulk of First Amendment cases involve state laws and state government actors rather than federal.
Yeah. Professor Volokh, in the next 50 minutes or so we have left, I want to invite you to sort of share with us some highlights about the evolution of the First Amendment. I appreciate that you and I can talk about that over 16 podcasts, obviously. Mm-hmm. Just some of the big stuff. There are a couple of things, for example, my interest, and you should not limit the conversation to that, but my interest is about, for example, hate speech or exception and restrictions to First Amendment. For example, we talked about libel. But whatever you wish, what are some of the big inflection points in the history of the First Amendment? And by the way, the First Amendment was not originally our First Amendment.
It was originally our third.
Our third. And two got kicked out, so this became first.
Originally, the first Congress proposed to the states, in response to many states' calls for amendments that were made when the states were ratifying the Constitution, Congress proposed 12 amendments.
12 amendments.
The first one had to do with basically a formula for calculating the number of members of the House of Representatives and how that related to the population, how many, what the population of congressional districts.
Kind of like apportionment of the seats.
Oh, apportionment, but not so much as drawing the lines, but indicating the size of each district.
Okay.
Population. So that was just didn't get enough votes. The Second Amendment provided that any increase in congressional salaries could only take into effect in the next election, or only take effect following the next election. That did not get enough votes until the early 1990s, when when it got enough votes and became what is now the 27th most recent amendment.
Wow.
To the U.S. Constitution. There's a story behind it, and I've read it in credible sources. There's a law journal article, and those are usually pretty well checked. That the amendment got some number of votes, but not enough to pass. It takes generally 3/4 of state legislatures at the time to enact an amendment, and then through the 1800s and 1900s, it got a smattering of more ratifications here and there. So then, 1982, there's this student, Gregory Watson, at the University of Texas, writes a paper for a government class in which he says the amendment could still be ratified. Look, it's gotten some more votes. If it only gets enough, then now it would have to be.
Was there a time limit for that amendment?
No. More recent amendments have had time limits, but that's
such as the equal rights
amendment,
yeah.
and many others.
Yeah.
What I remember is that he supposedly got a bad grade on that paper, and then he became I think a legislative aide. I want to say in the Oklahoma legislature. I'm working from memory here, so
yeah.
I'm mistaken some of the details. And in his spare time, he would fly around the country talking to state legislators and asking them to ratify the amendment. And this was politically a pretty easy ask because the amendment constrained the federal Congress. So state legislators wouldn't affect them unless they're expecting to run for Congress. It wouldn't affect anybody that much. They could still Congress could still raise its salaries. It would only take effect after the next election. And also, my guess is that some state legislators, even though they may have been political allies of congressmen, like the idea of kind of sticking it to these guys who got so big for their britches. They think they're federal legislators now. So in any event, so eventually enough state legislatures ratified it, and then there's this question: can you do that? And it went up to a particular executive official who is who I think this is the national archivist, I want to say, who had to decide whether to accept it or not. Now that in principle was just an initial decision. Like, he has no constitutional authority.
Yeah.
You could imagine Congress saying no, or the president maybe, probably not the president, because the president doesn't have much of a role in the amendment process. But nobody would have wanted to say no to him because it would have been politically bad to say no. I think it's kind of pointless because it is more symbolic than anything else.
Yeah.
The archivist says, looks good to me, and now it's part of the Constitution. Anyway, this is a digression, but I like to think a fun digression.
No, this was very fun. So 200 years later,
right? And the First Amendment was originally the third one.
Yeah.
And then the 10th was the 12th, and everything else in between. Actually, for some years, some decades following the ratification of what we now see as the First Amendments, some lawyers and some judges referred to them by their old numbers, which are too higher than.
You mean so our First Amendment now for some years was called in the early years the Third Amendment? You mean?
I think that's right. The particular cases I remember
that is
actually
interesting.
had to do with references to other amendments, but in principle, I think it would have been that way because if you came of age during that era, that's what you remember. There were 12 amendments, 3 through 12 were ratified, the others weren't.
Oh, wow, that is fascinating.
So in any event, history, well, I think this is why you're interested in history. I'm interested in history.
Exactly.
It partly it's so important in so many ways. It helps shed light on what's going on now, but partly because it just has these weird, fun stories, right?
It does. And going back to the First Amendment, I'm hoping that you share some inflection points if they're weird and fun, and that's icing on the cake. But what are some of the big stuff in the last 2 centuries that you think are important for us to know?
So the most important principle in First Amendment law is that all viewpoints, no matter how abhorrent and no matter how contrary to other principles of the Constitution, are protected against at least criminal punishment and the like. They're protected also against some other action, not always. Like, for example, the government, when it's giving out grants, can say we want to have, to give a famous example, National Endowment for Democracy, but not National Endowment for Communism or National Endowment for Fascism, right? That's a viewpoint distinction. But of course, when the government itself is speaking itself, trying to communicate some messages.
So if you are a KKK member, you can go and protest and you can write, and we hate it. We protect you for doing that. You can do that, but it doesn't mean that us, the government, are going to give you a grant.
Well, doesn't mean that the government will give you a grant if your application is, I want, you have a grant for projects in American history, and I want to have a project about what a glorious feature of American history the KKK has been. The government could say, well, we're not giving grants for absolutely anything on American history. We're giving grants for positions that we think are reasonable and interesting and generally worthwhile in American history. Yours doesn't count. On the other end, if the government were to say, if you're a KKK member, you can't get any grants, even if we're giving you a grant to, I don't know, we're building building a new fire station, and you're a contractor, and I shouldn't say that wouldn't be a grant, that would be a contract.
Yeah.
So we wouldn't give you any contract.
That would be discrimination.
We wouldn't give you a tax exemption. Yeah, that would be discrimination based on this person's viewpoint. Generally not permitted, but it is permitted when the government is saying we want to promote a particular set of viewpoints. And yes, we are going to discriminate in favor of viewpoints we want to promote and not viewpoints that we don't want to promote. So, but in any event, that's a little bit of a digression. The important point is that the First Amendment protects all sorts of views. This hasn't always been understood in American law, or not always been accepted in American law. Throughout American history, freedom of speech and of the press has been very broadly protected, especially by the standards of most of the rest of the world at the time, and by the standards even most of the rest of the world now. That throughout the 1800s, we had basically a working democracy. There certainly were many people excluded from the vote, whether because of race or because of slaves or because of sex or in earlier in some states because of a lack of property. But there were certainly debates, and there were debates, by the way, in which lots of people engaged in fact, even ones who were denied the vote. The people could argue to throw the bums out. They could argue against the current administration, and generally speaking, they were free to do so. So we had very broad protections, but at some point, the government said, no, if you're arguing for violent revolution, let's say, or before the Civil War in the South, if you're arguing in favor of abolition of slavery, that's just so dangerous because, it might lead to civil war, which it did, or it might lead to slave insurrections, slave revolts. Things that were seen as extreme enough, as extremist enough, were seen as subject to government control. And eventually in the...
Extreme enough in a sense that they would cause violence and insurrection.
Violence, or sometimes more broadly, violation of the law. So for example, during World War I, the Wilson administration, with the backing of supporters in Congress, but enacted laws that basically were then used to punish people who were advocating for draft resistance. And the theory was that this is, first of all, one facet of the theory was this is just encouraging violation of the law. And we have a democracy, and if the law is enacted, then people need to follow it. And if you're encouraging violation of the law, you're undermining the law and our democratic regime. Another feature was they said sometimes the court said, look, the Constitution protects all sorts of things, including free speech, but also the democratic process and the war power. And if what you're saying interferes with the government's ability to exercise its war powers, then that speech is itself kind of counter-constitutional. Then in the 1920s, that was also applied to radical pro-revolutionary speech, basically pro-communist or pro-violent revolution more broadly. So at the time, there was something that was labeled the bad tendency test.
Bad tendency test?
Bad tendency test. That speech could be restricted if it has the tendency to promote crime, including revolution, including draft resistance, including all sorts of criminal conduct. And that was potentially a pretty capacious exception, because you can imagine all sorts of speech, whether what today some label hate speech, which may be seen as promoting racist violence, or anti-gay or anti-trans or anti-Semitic violence, let's say, that would be unprotected, but also speech that sharply denounces the existing government might be unprotected because it might promote revolutionary violence, or sharply denounces the police, might promote anti-police violence. So all sorts of speech potentially was restricted.
Putting on my former lawyer hat, this bad tendency test seems so vague.
Well, it was vague. That was one of the criticisms that was levied on it, levied against it, excuse me.
Was this
And,
struck down as unconstitutional because of
well,
that
it was
vagueness?
eventually rejected in a case called Brandenburg v. Ohio in 1969.
Oh, 1969.
In Brandenburg actually, speaking of hate speech, involved the KKK. Although the law there was broader than the KKK. The law there dealt with basically it was basically advocating the duty, necessity, or propriety of crime, violence, and other unlawful methods of terrorism as a means of accomplishing industrial or political reform. So it may have been initially targeted at kind of far left revolutionaries, but it was, in this case, Ohio used it against an extremist white racist group, the KKK. And the Supreme Court said that law is unconstitutional. It's unconstitutional whether applied to left, right, or anybody else.
I see.
It said that even advocacy of illegal conduct, even advocacy of violence and revolution is protected unless the advocacy is intended to and likely to cause imminent lawless conduct. So a classic example is talking to a riled up mob outside some building in a way that causes them to go and burn down the building. Right there, it's imminent. You're trying to bring about, the speaker's trying to bring about something right away before there's an opportunity to really discuss this and consider it in a kind of a calm, rational way. So the Supreme Court adopted this rule and has stuck with it ever since. That's the basic principle that says that yes, if somebody wants to talk about how there should be again, violent revolution or violence against various groups, whether defined by race or by religion or by gender identity or sexual orientation or by being police officers or being ICE agents or being capitalists or whatever else, even that kind of speech is protected by the First Amendment. So that was a very important decision by the court, although Brandenburg is an important case, but it was part of a longer trend of decisions.
I see. Professor Volokh, when you were saying riling up sort of a rally, a group, I thought of the January 6th, 2021 attack on Congress. I don't specifically want to discuss that, but I thought of this question. Is there an exception for politicians' speech?
No.
There's not. I thought
there's a case on that.
There's okay.
And
I thought I remember something from law school days where in the well of Congress you can say whatever you want or something to that effect.
Right. So that is a separate matter.
Okay.
Let me first get to this question of there's a First Amendment exception for politicians, then we'll talk about the freedom of speech or debate clause.
Please.
So there was a case called Bond v. Floyd, 1966, and it involved Julian Bond, who was at the time a state legislator. And this was in Georgia, so in many ways very conservative state. But Bond was a kind of a Black political activist. He was elected in a overwhelmingly Black district. And he was very much out of step with the Georgia legislature, and he was expelled for statements that the legislature viewed essentially that were inconsistent with his oath as a state legislator. That his endorsement of certain practices of the Student Nonviolent Coordinating Committee was inconsistent with his oath. And they said, look, we're entitled to expel him because we're a state legislature and we can expel someone for whatever reasons. And the Supreme Court said, well, not ones that violate the First Amendment. Now, I oversimplify here, but as a general matter, the court's holding was that government officials have at least as broad First Amendment rights as ordinary citizens. Now, as with all broad statements, there are some exceptions. So, for example, we mentioned that Brendan Carr, you might say, violate, or at least one interpretation, which I think is the correct interpretation of his statements, was attempting to violate the First Amendment by trying to pressure the removal of pressure ABC to suspend Jimmy Kimmel's show.
Mhm.
Well, doesn't he have the First Amendment right to do that? Well, when you're a government official and have government power and you're threatening to use it in a particular way, that might itself be a violation of others' rights and not be protected by your First Amendment rights. But that's a narrow and kind of technical rule. As a general matter, government officials, at least executive and legislative, elected officials, generally speaking, have the same
Elected officials.
as others. Now, there's one exception, important exception as to elected officials, which is that elected judges, many states, of course, the great majority of states have elected judges, even though the federal system has appointed ones, but elected judges may be limited but by rules that limit judges. The government doesn't have unlimited authority to limit judges' speech. There was actually a case striking down some restrictions on campaign speech by judges, but it is pretty clear that judges could be barred from saying certain things like pledging to vote a particular way in a case before the evidence is heard and the like. So as always, in the legal, I used to be a math computer science major back in college. And actually my first career was as a computer programmer. I was a computer programmer for about 12 years. And my original love was math. And I was a little frustrated when I first came to law school. And I think many mathematicians, many scientists, engineers who decided to go to law school are frustrated because to them, laws are like the laws of nature.
Yeah.
The rules, there are no exceptions, right?
Yeah.
The mathematical principles, I oversimplify here. Some mathematical principles are pretty complicated. Even something as simple as division, can you divide things? Yes, but not by zero. You might think that's an exception. But if it is an exception, as opposed to just a property of division, it's a very simple exception. I can write out the rules of division for you very, very quickly. The axioms of math are easy to write down. Generally speaking, they're not just presumptions. They're not just general guidelines. They're the rules. But that's not the way the legal system works. That even the most important principles, generally speaking, have some exceptions. And sometimes as a lawyer, you articulate the principle. Somebody says, well, what about this exception? You say, yeah, that's right. But you don't want me every time I say something to try to list all the exceptions because it would take too long. It would be too distracting.
Exactly.
And I would never be able to list them all in any of them.
But I will ask you about this exception. It piqued my curiosity. You said elected officials. So that means that, let's say, our Secretary of War or Secretary of State don't fall under this.
Absolutely not. If a cabinet official says something that the president doesn't like, the president can fire that person.
Yeah. So
in fact, not even probably, that there's pretty broad authority that if Congress tried to limit the president's power to fire a cabinet official, it couldn't do that. No, the president has categorical power to fire cabinet officials, including based on their speech.
Yeah.
Or for that matter, political affiliation, right? Generally speaking, most government employees can't be fired based on their political affiliation. Used to be different. It used to be in many cities or states, Democrat wins, all the Republicans are fired from office, Democrats are hired. Then a Republican wins, well, the people appointed by the Democrats are fired, or at least many of them, and they're replaced with the Republicans. Starting with the mid-1970s, Supreme Court said that is unconstitutional. That in government hiring and firing, you can't discriminate based on party affiliation, just like you can't in many other contexts. But for high-level officials, of course you can. Of course a Democratic president can say, I'm going to appoint only or almost only Democrats to the cabinet. And if one of them says, oh, by the way, I was a Democrat when you appointed me, and now I've just decided I'm going to be a Republican. And the president says, that's so so good for you. That's, I really believe that people should follow their conscience. You just need to follow it outside my administration.
Yeah, yeah. And obviously that person has no First Amendment right.
Exactly.
Okay, that makes sense. Any other big highlights that you like to share?
Right. So the Brandenburg case I mentioned is the one that
Yeah.
says all viewpoints are protected. And one corollary that, racist viewpoints are protected. Anti-Semitic viewpoints are protected. Again, anti-police viewpoints, anti-capitalist viewpoints. There is no hate speech exception to the First Amendment. The Supreme Court has reaffirmed it, reaffirmed that on many occasions recently. So that's an important point. There are lots of others. Obviously, New York Times v. Sullivan is a very important case as a practice.
Of course, yeah. We did an episode on that, yeah.
Yeah, so I won't belabor it then, but that's the case that imposed First Amendment limits on libel law. It didn't completely reject libel law. Again, that's possibility of lawsuits and maybe even criminal prosecutions for false statements that damage people's repute.
Professor Wallach, isn't the Supreme Court revisiting the Sullivan case?
So there have been two justices, Justice Thomas most vocally and Justice Gorsuch in some measure, who have argued that the Supreme Court should reconsider New York Times v. Sullivan on the grounds that it is inconsistent with the original meaning and has caused various bad things. Then Professor Elena Kagan, some 30 years ago, wrote an article which expressed some doubt about New York Times v. Sullivan, although it doesn't tell us whether Justice Kagan is going to take the same view. But even that would be at most 3 justices who have expressed that view. Takes 5 for the court to reach a result. Takes 4 for them to agree to hear a case on a particular issue. Probably takes not quite necessarily more than 5, but sometimes even 5 will say, well, even if we don't like some precedent, we're not going to be willing to overrule it. So there's talk about the Supreme Court possibly revisiting New York Times v. Sullivan. It would be entitled to do that. It hasn't happened yet. And other justices had the opportunity to join Justice Thomas. Justice Gorsuch did agree with Justice Thomas that New York Times v. Sullivan should be revisited. But the other justices, including fellow conservative justices, haven't expressed that view.
And what would be the consequences of that if the Sullivan case was overruled? That was from back, I think it was Mississippi back in the 60s, and that really.
It was Alabama, I believe.
Alabama, okay.
So it's hard to know, and it's hard to know partly because it's always hard to predict consequences. Consequences can often be indirect and unexpected.
Yeah.
It's also hard to know exactly what the Supreme Court would say. So finally, New York Times v. Sullivan is a stand-in many people's minds, and I've used it this way too, for the revolution in libel law. The court worked starting with Sullivan. But there are different sub-doctrines there. So New York Times v. Sullivan dealt with public officials. It was then extended to public figures, which includes people who aren't elected or high-level appointed officials.
Like a celebrity?
Like a celebrity, like a prominent business person. Then it was extended to limited purpose public figures. Could be ordinary citizens who just decided to get involved in some debate, and they become public figures for purposes of that debate. Then there was a case called Gertz v. Robert Welch, which said, well, it doesn't apply fully to private figures, but does apply in part to private figures, ordinary citizens, at least on speech on matters of public concern. So it may be the case that the Supreme Court says we're going to preserve New York Times v. Sullivan itself when it comes to speech about public officials, people who are actually acting as high-level public officials. But this whole move to expand it to public figures and to limited purpose public figures and to restrict the recoveries available to private figures, that was where the real mistake was.
So that we're going to trim it a bit.
So we're going to trim it, but maybe not even as to the precise holding of New York Times v. Sullivan. Likewise, with regard to New York Times v. Sullivan, you can imagine the court either saying, oh, we were completely wrong. All of that is going back to the states where every state can decide for itself what rules to have about libel law.
Wow.
It wants to say even honest, innocent, reasonable mistakes, you still have to pay for them, just like some manufacturers have to pay on a strict liability basis for harm
Wow.
caused by their products. You say, wow, but that was the law in America for much of American history. And by the way, with state law limits, I mean, all states had actually limited libel law in various ways. It just would be left to states. Or you could say this, we were wrong to say that public officials can only recover based on knowing or reckless falsehoods. They should also be able to recover for negligence falsehoods, or maybe grossly negligent
I
falsehoods.
wonder what the repercussions of that would be on social media stuff, where you're reposting someone, when you're getting information from that could be very widespread, right?
So it could be, although of course there's a federal statute, 47 U.S.C. section 230, which provides protection for people who basically just repost other people's stuff. And by the way, even before New York Times v. Sullivan, there was a defense recognized, I think, by the great bulk of states, called the wire service defense, because it originated when a newspaper reposted something for a wire service like Associated Press. But it was extended to any time somebody forwards something from a credible source, like from another newspaper. So there might be still protections offered by various states, maybe even by all states, for certain kinds of speech. Again, it's not like because of libel law, we lacked free speech in America until 1964. It is true that there were certain things that were more dangerous to publish. Maybe there were certain true statements that newspapers didn't publish for fear of liability. Maybe there were lots of false statements as well that they didn't publish for fear of liability. I'm not a foe of New York Times v. Sullivan. I do think it's inconsistent with the original meaning, but I'm not a thoroughgoing originalist. Maybe better the devil we know now than the devil we don't.
Yeah, exactly.
Old system. But it's important to recognize that there are different ways different possible solutions to the libel problem. New York Times v. Sullivan is one, but before that, we did have a very lively media.
Yeah, of course.
And we did have a lot of coverage of political scandals. So it's hard to know what would happen.
Yeah. Let me bring our conversation to a close, Professor Volek, with this question. If you wanted our audience to remember just one point about the First Amendment with respect to freedom of speech, what would that one point be?
That one point. Well, it's hard to capture it all in one point. And really, it all depends on what I'm worried about people, what mistake am I worried about people making? So one point might be, First Amendment protects all viewpoints, hateful, loving, and everything else. That's a good first step. That's an important point. Another important point, of course, is that the First Amendment does not apply to private entities. It only applies to federal government, state, and local governments. That's also an important point.
Yeah.
Again, some state laws may restrict, say, private employers from firing employees based on their speech, at least in some states in certain situations, but not the First Amendment. So those are two big important points. There are lots of other important points.
Of course. Those are good points. Professor Volek, thank you so much for educating me and our audience. And to our audience, if you know of any history that could provide more perspective from the past on this subject, please share it with us and tell us what's your perspective. Thank you so very much. This was wonderful.
Very much my pleasure. Thank you for inviting me.